cannot continue to go with unsettled provisions indefinitely. There are issues which I will not touch upon, but these are burning issues in my mind. I have a bounden duty as the Minister for Law and Justice to take into account certain issues which are unsettled, not only because of my opinion, but because of the fact. In a similar fashion, we talk about rule of law. When we talk about rule of law, the mechanism for delivering of justice is the key. And if you see whether it is judiciary, executive or legislature, the purpose is same. It is to give justice to all. Now, how things are faring in our country? If you see 5 crore cases pending, what does it mean? In states like Uttar Pradesh, close to 1 crore cases pending. If the matters as serious as murder, rape cases are not getting the dates for hearing for 2 decades, more than that, what does it mean? It poses a serious question into our justice delivery system. Now somebody can ask me in Parliament, I am frequently asked this question that as a Minister for Law and Justice, what are you doing to reduce the pendency of the cases? I am doing whatever it takes, all necessary steps. But I know many more steps are required to be taken. But judiciary, as being a separate organ, I can only work to enhance the capacity of the judiciary. So my point is not only to maintain the independence of judiciary, but to strengthen the Indian judiciary. So I am doing whatever it takes. I will not count on what the steps I have taken because there are a series of initiatives which have happened in the last 8 years. But what I am going to say is, the internal mechanism within the judiciary needs a transformation. Without that, the pendency cannot be reduced, and the rates of pendency are alarmingly increasing day by day. If you are settling 20,000 cases a day, 30,000 new cases are coming up. So it's not that cases are not settled. More new cases are piling up. These are huge challenges before the nation. So I have made a very forceful appeal to the Indian judiciary that when it comes to the justice, it is not the judiciary or government, but it is both. Along with the legislature, we have a combined responsibility to ensure that we change the way in which justice is delivered. So when we talk about Indianization of the Indian justice system, we talk about getting justice closer to the people. That means localization of the justice delivery system. That means we have to work as a team. Language sometimes becomes very important part in the justice delivery mechanism. Because what I find is, the person concerned is totally unaware of what is going on in the court. How can it be? So that is why when I say localization, taking justice closer to the people, that means it is not a dialogue between the lawyer and the judge, but it is the person for whom they are deliberating. He must be aware of what is going on. Now if we talk about language, I am in favor of introducing Indian languages in all the courts of India. Because I find that the higher judiciary is in the captivity of the few influential lawyers who command great power and authority over English. That is okay. There's no issue in that. But what about the other lawyers who are very well, tuned to the Tamil language, Assamese, Bengali, or Marathi, Gujarati, Punjabi, Kannada? We have to ensure that there must be level playing field. Judiciary cannot become a domain only for a particular language speaking group. We have to understand that India being the largest democracy, and today we are the most populous nation in the world. How can we be guided by the ethos of the countries outside our system? There are lots of issues which comes to mind, but as I said, if I touch upon so many burning issues, it will take longer time. But I just would like to speak about how we want to transform Indian judiciary. The foremost thing which comes into my mind is the use of technology. Do you know how Indian courts kept on functioning during the pandemic, COVID-19? The doors of the courts were not closed because in the e-court phase 2, we had made a very strong provision and laid a strong foundation to ensure the court will keep functioning despite all physical obstacles which we have seen. So in 2015, we have made a quantum jump in making all